This interaction is a clear example of police overreach mixed with legal confusion. Officers attempt to coerce identification by presenting a false choice: provide your details or be arrested. As the encounter unfolds, the officers struggle to justify their actions, inventing a supposed power to detain for questioning. The most serious mistake comes when they try to rely on Section 19 apace, a power limited to premises, to justify seizing equipment on a public street.
Or I can arrest you.
Yeah.
So that.
What's the details? Can I ask your name and address? Name and number, officer.
Can you grab my phone so that I can?
You've just seen us outside the police station.
Can you identify yourself,
right,
please?
Can I explain why I've stopped you?
No. Answer my colleague's questions. Thank you.
Identify yourself, please.
A person who was entering the property said that there's potential public order offences that have been reported. Therefore, I can require your details so that can be investigated.
No.
I'd like to do that rather than arrest you, so that we can deal with it now.
No,
so let me just confirm.
Can you identify yourself, please?
You've not done that so far. Are you a constable or are you an impression?
I am.
That constitutes an offence.
11733.
Sorry?
11733.
From the very start, the officer approaches with unnecessary aggression, offering a false binary: give me your details or I will arrest you. This is a coercive tactic. Under English law, specifically Pace Code G, an arrest must be necessary, not merely possible. You are not legally required to provide your name and address unless you are under arrest, being reported for an offense, or involved in specific traffic matters. Mentioning a potential public order offense is meaningless. The legal standard is reasonable suspicion. Threatening arrest to shortcut an investigation is a clear failure of due process.
3. On police. Can you offer me a number? Thank you. So at the moment I'm going to talk to this officer here, because he's the one who's approached us at the moment.
Possible public order offence.
For what? For
I'm
standing
just trying
outside
to-
the gate? No, I don't think so.
No, just due to an interaction you had with them. That's the report I've got from them.
What interaction?
You also get to report and tell me what you want. So
We don't want to
that's
say
fair
nothing,
enough.
thank you.
There you go. If you don't want to say
No
anything,
comment.
but they did want to say something. So
Well,
unfortunately, when a crime is
It's not a
reported,
crime.
that
Public
gives me
order is not a
powers
crime.
to A, stop and detain you, to deal with that crime, and if required, arrest you.
Yeah,
My colleague now is just taking those details.
that's a load
The
of crap, I
report
think.
was, and once I know more about the report, I'll be able to tell you more. However, until then, I'm going to take some details.
No, thank you. Not until we know more details, at
Okay.
least.
You've been threatening people, you've been intimidating people to come in by putting
The officer claims he has the power to detain someone to investigate. This is a major red flag. In the UK, police do not have a general power to detain people simply to ask questions. What is often described as an invitation to stay is entirely voluntary unless a specific power is being used, such as Section 1 PACE, Section 23 of the Misuse of Drugs Act, or an arrest. Without that, you are free to leave. Detaining someone to fish for information based on hearsay is an invented power that does not exist in law.
That's a lie.
They felt
That's a
intimidated
lie.
by it.
Well,
They don't want to, they didn't ask for it.
Are you the feeling police then, are you?
The feelings police.
The feeling, yeah, because they feel intimidated, you have
If
to
people
deal
feel
with it.
intimidated and threatened by it, they don't like it.
Well, that's their problem, not mine.
If
or
some people
yours.
intimidated you, you want us to investigate.
No,
wouldn't you?
no, because I've already been through that one and they didn't do anything about it. Right,
That's
so
you. But other people, if they feel
no,
threatened or
police didn't do
intimidated,
anything about it.
they want us to speak to them on that.
Because
That's
it's the
what we're doing.
police, you're doing something about it. And we haven't committed a crime. There's no law against us filming
No,
outside.
I'm not saying
so,
there's a law against you filming.
so we haven't committed any crime.
I don't mind you filming. Crack on.
and we're filming from a distance, and there's evidence of that
So
on my camera, his
their
camera, and
feelings
cameras
don't come
of
into
that.
it. Their feelings don't come into it
Why not?
because they're police. You have
says they're
you have a
police?
higher tolerance.
Who says they're police?
They're control staff, whatever.
Who says they're
They
police?
work for the police.
Do you know who?
A second officer enters, claiming members of the public feel intimidated. It is essential to remember that feeling intimidated is not a criminal offense. For a Section 5 Public Order Act offense, there must be threatening, abusive, or insulting words or behavior. Filming from a public place does not meet that threshold, regardless of personal feelings. Police officers are also expected to have a higher tolerance than the general public, a principle known as DPP v. Aurum. Here, the officers are policing emotions, not enforcing the law.
Well, please,
How do you know?
because they showed their ID badge.
There might have been a police case on it.
Yeah.
There could be a civilian member of staff.
Well,
You don't have to find
they still have a high tolerance
How do you know that?
because I do. You
Because
have
you do.
If I swear, if I keep swearing and swearing, you can't do me for it because you have a higher tolerance.
Yes, we can.
Yes, we can.
Under Section 5 of the Public Order Act,
You have a higher tolerance
can.
if I'm swearing to you than I was
You don't
swearing
know
to
who
public.
you're talking to there, do you?
Okay.
I wasn't talking to
You
nobody.
don't know who they are.
I'm talking to nobody.
You're putting the cameras in front of their faces. You don't know who they are.
That's a
The
total
lady
lie.
spoke to me, so in interaction I filmed it, which I'm not allowed to do.
Yeah.
So there is no crime here whatsoever.
If they're intimidated by it, they will-
okay,
they
but
will-
under Section 19 of the Police and Criminal Evidence Act, when a crime is reported, and I can
It's
see...
not-
This is the most critical moment of the encounter. Officer ARV6 cites Section 19 of the Police and Criminal Evidence Act to claim he can seize the phone. This is a serious legal error. Section 19 applies only to officers lawfully on premises and does not grant power to seize items from a person on the street. Attempting to use a premises-based power on a public highway is legally illiterate and, if carried out, could amount to theft or trespass to goods.
Ready, I can take and seize any articles that may provide evidence of an offence.
And then I'll sue you.
So,
And me.
as I'm saying, you're saying you've recorded it, therefore that almost makes, I can 100% guarantee there's evidence on those machines.
But we didn't do anything.
Okay, so let us just have a chat.
Exactly.
Let's see what was going to happen. Okay, and we'll get to the bottom of it. We're not being argumentative with you.
You are,
We're
'cause
telling
you're trying to,
we were trying to leave. I
we
didn't have an
told-
issue.
We
Hang
were
on.
trying to leave and you
Hang
stopped
on.
us.
And I didn't have an
Exactly.
issue.
Exactly.
However, prior
That's
to
the
me
issue.
leaving,
My issue.
someone reported and told us via the radio that they said that you were aggressive towards them.
Rubbish. That's lie.
Hang on,
Go and tell them the lie and
Does
do
it-
them for lying to the police.
hang
then.
on, hang
You
on.
felt intimidated, all right?
No, you said they said we.
Sorry, intimidated, aggressive and intimidated. Okay.
Well, wasn't
However,
aggressive,
listen,
that's a lie.
Listen,
And
you're
you got-
interrupting.
The officer admits he is acting on a third-party report claiming the auditors were aggressive. While police may investigate reports, they must objectively assess what is happening in front of them. The auditors are calm and nonviolent. The threat to seize the phone to check the evidence is nothing more than a fishing expedition. The officer is attempting to reverse the burden of proof, demanding the auditor prove innocence instead of the police proving a crime. Standing firm here protects both privacy and property rights.
Then get to come and ask you and say that's what's been said. You get your chance to tell me.
Well, that's a lie.
Okay.
We
Nasty
didn't
character,
do-
mate. Him.
That's a lie.
But when a criminal offence is being alleged, and one has, we are entitled to do that.
Look at that ugly face he's got. Do you feel offended by that? You shouldn't do. Just let them get on with what they've got to do.
So why didn't you stop outside the gate instead of stopping there?
That'd be more
Because we
appropriate.
didn't get told until we got there. But thank you very much for.
I bet that's a bit of a porky pie. Literally porky.
So can I report a crime?
If it's genuine,
Yeah.
If it's genuine.
I feel intimidated. I feel that you're being aggressive, so I'd like to report that.
okay.
That's not reporting a crime. That's reporting a complaint.
That's a crime. You just said it was a crime.
The officer states, "I feel you are being aggressive." This is a common tactic used to justify a breach of the peace. However, asserting legal rights, refusing to answer questions, and filming police in public is not aggression, it is lawful civil resistance. The officer is attempting to gaslight the auditor into compliance by rebranding non-cooperation as hostility. The auditor's calm demeanor removes any realistic claim that a breach of the peace is imminent.
You saw us down in outside the station when we was out there, but you didn't want to stop us because it's raining. You got in your little car, you left, let us do what we wanted to do, go home, or go at the next location, and you got in your car, you thought you'd be cliffing that to waste our time, but it ain't really waste our time, is it?
I appreciate your opinion.
That's my opinion.
At this point, the encounter stalls. The officers realize the auditors understand the law. They have no name, no address, and no seized phone. This demonstrates the power of saying nothing and holding the line. Had the auditors given in, the officers likely would have issued a warning or community resolution to save face. By refusing, the auditors forced a choice: make a false arrest or walk away. The law favors the auditor.
Okay, again, so as I said, and typically it's now going to get noisier.
Yeah,
as I said, a crime was alleged. I'm going to ask you again, will you provide me with your details? I'll apologise, I couldn't hear your answer due to the loudness of that machine.
No problem. Yeah, no thank you.
You said no? No. I still can't hear you.
No.
No, thank you.
We haven't committed a crime.
Exactly.
Well then, unfortunately you're entitled to your opinion, but when one is alleged, I'm entitled to mine.
In a final attempt, the officer circles back to the beginning, using the noise of a street sweeper as a pause before asking again for details. This repetition exposes the bluff. If the necessity test for arrest under Pace Code G, specifically to confirm name and address, had actually been met, the officer would not be asking. He would already be arresting. The fact that he keeps asking confirms there was never lawful necessity.
At the police station, it's over there. Right, and we left there. We was walking by. Now this car's just approached us. It's obviously a police vehicle, and it's the armed police outside Cold Harbour
I think I've met before somewhere else.
police station.
On another occasion, and they've got intentions to go to another location after this.
Yeah, I'm going back home. The next location for me, bed.
Okay, there'll be a report made and we've got your descriptions, okay?
Yeah.
Lovely.
We've done is on camera as well.
You felt you'd done some work today for the public. Got my description, our descriptions. No one's offended at police station.
Enjoy your days.
Enjoy your day.
You too.
Thank you very much for the photography. It's not a crime in public. I'll make sure they remember that in a minute. Get their fucking numplate after that.
As the officers leave, the auditor records the vehicle registration, best practice when preparing a professional standards complaint, particularly concerning the misuse of Section 19 PACE. In summary, the officers failed to identify a specific offense, attempted to police feelings rather than law, and demonstrated a concerning lack of understanding of their own seizure powers. This interaction is a textbook example of why auditing matters, to hold officers accountable when the law is misapplied.